Hello everyone, happy Friday to you. Welcome back. Thank you for being here. Welcome to all my mods, patrons, members, subscribers, locals, anyone that's new here as well. Of course, it's document time again, as it is in Delphi. The documents never stop, which is great. Okay, there's always progress in the case, but my goodness, there's a lot of things to work through, so I thought we could talk about that a little bit today. Please like and share so that others can also find the stream. One request would be to not share any hashtag to do with Richard Allen, along with hashtag justice for Abby and Libby, because that definitely upsets the families a lot. So they've expressed that on social media, that they created hashtag justice for Abby and Libby. You could use that on its own if you want. Don't put it with hashtag Richard Allen or any of the other hashtags. Okay, so are we ready? This is an old document. If you see it, you're like, I've seen this before. This is not a new confession, Gisela. I just wanted to show you this because we've been over this before, because I was interested when I read the new document about these, more confessions to other inmates and guards that Richard Allen allegedly made. Then I was like, is that in the same time frame as the original confessions that we heard about, to his wife and mother? Yes, those ones. So I just wanted to see if it was, and it does seem to be. Okay, so we're quickly going to go over this, a little bit of backstory, okay, and then we're going to get into the new stuff. Breathe. Thank you so much, and thank you for reminding everyone to hit the like on the way in. That helps others know about the stream if they didn't get the notification or things like that. You said thank you, G, for covering this case for us. Of course, my goal in covering this case is, of course, justice for the victims, right? At the moment, there's a secondary focus that's happened in that, of course, I would hope everyone wants a fair trial for Richard Allen and for him to be treated just like any other defendant, any other suspect waiting for trial. And I see an anomaly here, So I just feel like the way that he's been treated, the way that things have gone, the bias that we see from the judge, what the state is saying, it just doesn't feel in my gut like something one can really trust, something that's how it normally works. And, I'm a goody two-shoes. I'm a rule follower. So when I learn the rules, like how does a country work? How are they supposed to work? And we see, for example, Brian Koberger always swaggering in with his suit. We see Chad Daybell, who's accused of murdering children, and his wife, all comfortable sitting there in the courtroom, and then you see Richard Allen. It's different. I know different states have different rules and all of that. I'm just seeing some anomalies here, and I just keep reporting on it because I'm very concerned about how this is going, right? Okay, Java Junkie says the trust is completely gone in my eyes, right? So I'm just making that clear because, of course, if you follow me on X, you see there's a lot of lot of talking there. And not once have I said he's innocent or guilty. He's innocent till proven guilty. Make sure that there's a fair trial so there can actually be justice for the victims and their families. If you don't have the right guy, make sure you get the right guy. If you do have the right guy, make sure there's a fair trial. Make sure he makes it there alive as well, in a good mental state. Okay, welcome, Dizzy. Nice to see you in chat as well. Okay, so this was a document from, page 7 is where I want to go. From April 20th of 2023, when these original confessions came up and they said charges were filed against Richard M. Allen on October 28th of 2022 for 2 counts of murder. If you know nothing about the case, check out the description box. There's a little write-up there for you, and there's a link to the playlist, okay? Once Richard M. Allen was taken into custody, he was moved to the Westville Correctional Facility, which is part of the Indiana Department of Corrections for safekeeping. He has been, I'll make it bigger for you, in said facility since November of 2022. When Richard M. Allen entered the facility, he was placed in the segregation unit for his protection, which makes sense, right? Hence, Mate's Tale says, any comments from Doug Carter lately? Nope, there's a gag order, so no comments from him. So, in the segregation unit, his cell is equipped with a video recorder which records his activities within the cell. There are also logs indicating when Richard M. Allen leaves the cell and for what purposes. He's also being seen by medical providers and mental health specialists to evaluate his physical condition and monitor his mental health. Richard M. Allen also has the ability to use a tablet in his cell to send text messages, make phone calls, and listen to music. Obviously now he's in the Wabash Valley Correctional Facility, right? This was the Westville one. He was moved, which is quite far away from where the courtroom is and where his lawyers are and all of that, and we've gone over that before. The reason I'm also doing a little bit of backstory is just to remind us, to refresh our recollection, and for those who don't really know much about this, right? So this was from the state. The defense then had a response to it. That's where we saw Exhibit A and B, you know, when Richard Allen had the, I don't know what, a little wet patch on his shirt, and his hands were like this in that like red prison outfit, and people say that the defense made him look like that to make it look exceptionally bad, right? Okay. So they said the facility reports that he was doing well, that they had no issues or concerns. His day-to-day demeanor was that he was quiet, read a lot of books, did crossword puzzles, and exercised daily. That sounds pretty normal. On April 3rd, just pay attention to the timeline now, 2023, Richard M. Allen made a phone call to his wife, Kathy Allen. In that phone call, Richard M. Allen admits several times that he killed Abby and Libby. Investigators had the phone call transcribed, and the transcription confirms that Richard M. Allen admits that he committed the murders of Abigail Williams and Liberty German. He admits several times within the phone call that he committed the offenses as charged. His wife, Kathy Allen, ends the phone call abruptly. Soon after, attorneys for Richard M. Allen filed an emergency motion to modify the safekeeping order. In that motion, the defense states that Richard Allen's mental state has declined because Westville Correctional Facility is unfit and that he should be moved, which he later was. The defense also makes allegations that his mental health has declined to the point where Richard Allen has been deprived of his constitutional right to assist in his defense of this case. Further, the defense alleges that his mental capacity has declined because of his incarceration at Westville Correctional Facility. The defense has also challenged that his treatment is unconstitutional. Soon after, investigators were made aware by the warden of Westville Correctional Facility that Richard Allen began to act strangely. Richard Allen was wetting down paperwork that he had gotten from his attorney and eating it. He was refusing to eat and refusing to sleep. He'd go days on end refusing to sleep. He further broke the tablet that he used for text messages and phone calls. He went from making up to 2 phone calls a day as of April 3rd of 2023 to not making any phone calls at all. To date, Richard M. Allen still has not made a phone call since April 3rd of 2023. Okay? So it goes on. I'm going to quickly read the last 2 paragraphs here. We're going to see the defense's response. We're going to see the new confessions. Okay. Let me know what you think. I say it like this because we got to just see what they say in the trial. Of course, okay, we've got lots of commentary to make. Let me first read this. On April 14th of 2023, Richard M. Allen was evaluated by 2 psychiatrists and 1 psychologist to discuss his turn in behavior and whether or not there was a need for involuntary medication. The panel would also discuss moving Richard M. Allen to a different facility that has a psychiatric unit. From that meeting, it was determined that Richard M. Allen did not need involuntary medication. Also important because then at the new place, they started giving him all sorts of medication, which is odd if they say he didn't need it, you know. Then they're like, well, that's it. We're going to dose him with, I don't know what's going on there. And Bing says, hope these recordings aren't in the lost pile also. Right? Where are those recordings? And what did he say in it? Okay? Because we still don't know what he said. We're going to know more or less what he said in the new document to guards and other inmates. Okay, so they say here, from that meeting it was determined that he did not need involuntary medication and that he did not need to be moved to another facility. Since that meeting, Richard Allen has begun to eat again, has begun to sleep. His behavior is returning to what it was prior to the admission on April 3rd of 2023. Investigators believe the information that Westville Correctional Facility has gathered since Richard Allen was placed in that facility is important to the investigation. Investigators believe that there's video evidence that will include his admissions plus his behavior prior to the admission and directly after. Interesting. Okay, investigators also believe logs kept of his daily routines are important to determine when he was in his cell, when he was removed, and the reasons that he was removed. Further, any records of physical exams and or mental exams will be important to determine the state of his mental and physical health. This information is needed to refute the allegations made in the defense's emergency motion to modify safekeeping order. The evidence is also necessary to refute the allegations of diminished mental capacity and or other possible defenses. It may also be important as the state introduces additional evidence gathered, including admissions made by Richard Allen himself. Investigators believe all information is important in the continued investigation for the murder of Abigail Williams and Liberty German. Then, of course, the defense responded. We looked at this before. They say that Mr. Allen has been entombed in a cell as small as 6 foot in width by 10 foot in length, and a space no larger than that of a dog kennel. Mr. Allen is sleeping on a pad on a concrete floor. He's afforded showers only 1 to 2 times per week. He's required to wear the same clothes, including underwear, for days on end, which are soiled, stained, tattered, torn. Who is Mr. Allen, a constitutionally innocent man, maintains his factual innocence as well, has not been afforded any opportunity to visit his wife or other family members during the last 5 months of incarceration, during which time he has been subjected to conditions akin to those of a prisoner of war. Do you remember this? Do you guys remember this? Should we move on to the new confessions? So they detailed, we've gone over this before, it's on the playlist, right? How they believe he's being treated. Okay? So, here's the new document, okay? This is 11 pages. Shall we read through it? Phantom says tased by a guard. Now, if any of the defense's allegations are true, that is concerning then, right? If he's being tased by guards, if they're saying you want to shower, and then they're shaking their head, no, you don't want to shower, because we've heard that before as well. All sorts of things. If there's really these Odinist guards with patches on their clothing, which they provided affidavits to say, yes, we are there, and we do wear the patches. When they're then told not to wear the patches, they tattoo it on their face. That was true. I always thought that's going to come back and be like, yeah, that's probably not true, right? Odinist guards with patches at work? I don't think so. Sorry, let me just make this light a bit brighter. I don't know about that, but it actually ended up being true. So that's a little bit concerning. A lot of the things the defense initially said, people were like, psh, you know? And you guys know, I normally sit on the fence. I'm like, okay, let's just see, let's wait. But then I'm like, there's actually affidavits to say that they are? Okay, interesting. So we just take it all into consideration, especially in case, imagine if he really is being treated that way, which we just don't see. I can name so many defendants, we just don't see them being treated that way, right? Pernille says, and he's in prison and not in jail. Some argue that it's because he was, they need to keep him safe. But as David Hennessy said on a recent live stream with Defense Diaries, if you don't know who Hennessy is, I hope you'll catch up because we've done so many episodes discussing all of this. He's the attorney representing the attorneys, the defense attorneys, right? Because he thinks something isn't right here, much like many of us think something isn't right here. So he was saying, well, he's represented people who are accused of murder, murdering children, or double homicide, or whatever it is, and they're not in prison. They've never in their careers between those three defense attorneys, they've never seen this. So it's not like, obviously, in Indiana, this has to happen. He has to be kept safe. This is not normal. This is an anomaly. And there's a lot to be concerned about, in my opinion. The trial is 31 days away. Can you believe it? 31 days. Okay, so this is the very important document. Thank you to Grizzly Cat and MB Inc. for sending me this. I really appreciate it. Love getting documents. Okay, here we go. Memorandum of law in support of the defendant Allen's motions to suppress. So what they want is to, it's actually this one. They have filed this motion to suppress statements, okay? We'll go over that afterwards, but this is the memorandum to support that, which has more information, of course, right? Deanna, I think you're confusing the case with the Long Island serial killer. These ones didn't get divorced. Okay, if you're not seeing the live chat, then here we go. Well, let me put the comment on the screen. They say, wife, I thought they got divorced to prevent losing the house and other income in the bank. Not these two, right? Okay, so facts. So they say facts. Defendant Allen was arrested in October of 2022 and immediately detained in the Carroll County Jail. Allen was thereafter transferred to the White County Jail and ultimately charged with 2 counts of felony murder. The charges were lodged against him on October 28th of 2022. On November 3rd of 2023, the Carroll County Sheriff petitioned the court for an order transferring jurisdiction of Allen's custody from the Carroll County Sheriff to the Indiana Department of Corrections. On the same day. Now, this is where the red flags come in because it's all just like, oh my word, all the events. There's a lot of strange things in this case, right? And it just keeps getting stranger. So they say on the same day, and without the formality of a hearing on the sheriff's request, Judge Benjamin Diener signed an order, a safekeeping order, transferring Allen's custody to the IDOC without Allen or his legal representatives having any input into his pretrial detainment. Allen was then shipped off almost said shipped off to the Westville Correctional Facility and placed in a maximum security segregation unit referred to by prison officials as WCU. I mean, again, that could be for his safekeeping because it's a high-profile case and is accused of murdering children. I understand that. But for the judge to also recuse himself on the same day, like sign off, recuse himself, it's just, there's a lot of strange coincidences in this case. And as former law enforcement will tell you, like Joe Giacalone, is like, there's no such thing as a coincidence, right? So there's many things here that's like, interesting. Analysis of a crime with CD, welcome. So they say the records suggest that just prior to his transfer to the WCU, by the way, if you didn't catch it, this is the new document that we're looking at now, okay? We went over the backstory. Now we're looking at the new one, which will contain the new confessions. Okay, the records suggest that prior to his transfer to the WCU, Alan may have made a brief stop at the Reception Diagnostic Center, RDC, where some sort of intake procedure may have taken place. But it does not appear that Alan underwent any formal mental health assessment or testing to establish a baseline in terms of his mental health history or needs, which normally they do. We see them do that. We saw it for Letitia Stowe, for Sarah Boone, Jessie Kershevsky, and all these ones. I know I just named 3 females. All of them, they do it, right? Usually. Thank you, Mary Ann, for making it, and happy Friday to you. You said thanks for all the work you do. 90 hours a week for us. Okay, that's no lie. I work a lot. So I really enjoy it, though. I really enjoy being here with you. So they said, so do you find that strange or not? Like, honestly, keep an open mind. Do you find it strange or not? If you don't, that's okay. If you do, that's okay too. We're allowed to have our opinions. Don't fight with each other. There's a lot of fighting in this case, right? Now, they say from approximately November 1st of 2022 through December of 2023, Alan remained incarcerated in the WCU. Alan's attorneys are unaware of any other pretrial detainee that has ever been housed in the WCU in the history of the facility, and most certainly not in the 5 or so years preceding his placement. Could that be because it's such a high-profile case and his life is so in danger? Maybe. Or what? Now, at the time, they say here, I'm reading the footnote, at the time the court signed the safekeeping order, Alan had yet to be appointed counsel. In fact, Alan's court-appointed public defenders, Rosie and Baldwin, did not enter the appearance until November 14th of 2022, and therefore Alan had no input. I think that's a bit dodgy. Before he even has any lawyers assigned, they're like, move him to there. Okay, so they say Alan had no input to his pre-trial detention circumstances. The record should also reflect that the safekeeping order and all other exhibits referenced herein have been personally served on the court in the form of a supplemental appendix. Tippy says, love this channel. Oh, thank you so much. Okay, so Alan's attorneys have conducted depositions, watched video from Alan's cell and other video from within the prison, reviewed prison records regarding Alan's detention, reviewed Alan's medical and psychiatric records, and listened to audio interviews of prison inmates and guards conducted by law enforcement officials. Through this process, Alan's attorneys have learned that Alan has been accused of making incriminating statements to both inmates and guards. Nearly all of these statements appear to have occurred between, that's why I said earlier the timeline is important, it's what got me curious and I went to dig out those old documents, right? So, between mid-March of 2023 and June of 2023, right? They say nearly all of these statements appear to have occurred in that time frame. That's when his mental health went to hell, right? And I wouldn't wish that on anyone. I do not understand how people can read this and mock Richard Allen, laugh at his mental health, say that this is okay. I don't think it's okay. He is innocent right now until proven guilty. And the case doesn't seem all that strong against him, and I know we don't know everything, but it's not that hard to come to the conclusion that this might actually be botched. This could actually be a case we see in history that could be a wrongful arrest and or wrongful conviction. How do we know? We don't know. We're not the jury. We're not the judge. We're not there. The trial hasn't started yet. But imagine if it is. Wow. Okay, so they say through this process, they've learned that he's been accused of making these incriminating statements mid-March, 2023 to June. During this time frame, there also exists medical or psychiatric records suggesting that Alan was in a state of psychosis. They've mentioned that before. Alan's defense team has learned that Alan was not only detained in an isolation cell in WCU, but that prison officials chose to post inmates at Ellen's cell door and required the inmates to keep logs of all of Ellen's actions, statements, and behaviors. This appears to have occurred during all hours of the day and continued over the course of much of Ellen's stay in the WCU. These inmates, all of whom are convicted felons, in a maximum security prison, I might add, right? There we go. Analysis of a crime with CD says it's never happened before because it isn't normal protocol. And I can't stand it when rules are not followed, when there's a standard that's set, when there's a protocol to follow. I don't know if it's my airline pilot background or what, or if I'm just a damn goody two-shoes, okay? But I like to follow rules, and I like to know what the rules are and to understand. So in this case as well, remember, I'm not a lawyer. I'm trying to understand what is going on here. Why is this so strange? What are they doing to this guy, and why? Why? Okay, so they say, so they had these, they initially had these prison officials. The prison officials chose to post inmates at Ellen's cell door and require them to keep logs of all of it. Ellen, is that normal? Is that normal? Why aren't they watching him? Is that normal for other inmates to be watching him and probably taunting and all that? I don't know. Anyway, so they say these inmates, all of whom are convicted felons, were not only actively engaged in surveilling Ellen's activities, but were also communicating with him from time to time. Ellen's attorneys have also learned that at some point in early April of 2023, prison officials deliberately pulled the inmates from Ellen's cell door and then replaced them with prison guards, which one would think is a good thing, unless they're odinous with patches on their face, tattooed on their face, wearing the patches, and then they have to take it off, and then it's like, okay, we're going to tattoo it on our face. Strange. And then they brag about it on their own Facebook. This is not a myth. It's not something that's just being said. Like, here goes Gisela with those odinous again. They're out there, okay? They're on Facebook bragging about their own making runes, having tattoos on their face. It does exist. It's not a mystery. Okay. So, Ellen's attorneys have learned that this appears to have been prompted by an inmate or inmates engaging Ellen regarding his pending charges and communicating Ellen's thoughts and words to the families of these inmates, thereby violating any sense of confidentiality that might exist within the walls of the penitentiary. Most notably, Ellen's living circumstances within the prison appear to have been designed, whether intentionally or unintentionally, to expose him to some of the harshest conditions that even the most heinous of convicted offenders have not endured. Why? Why is he put in that situation and Chad Daybell isn't? Adam Montgomery wasn't. Brian Koberger isn't. Chris Watts wasn't. I can name many. Why? Why does he have to go through that, but all the others don't? It's weird. Okay. So, guilty of crime, says Richard Allen, is guilty. Get your pitchforks out. He's guilty. In fact, if you're American, according to your constitution, no, he's innocent right now until proven guilty. And just like me, you don't have all the information. Okay. So, we got to wait for the trial, which, are we going to see anything? I don't think so. Are we going to hear anything? Maybe. Apparently, according to the law, they have to release the audio eventually. It doesn't have to be on the day like Lori Vallow's trial. Maybe one day we'll have access to the audio recordings or the transcripts of the trial, but I don't know. It's only 31 days away. All right, so they say this coercive environment, okay, also, I think it's the same person, right? Guilty of crime, and you remember that's so hectic. Okay, you say this is how it is in prison. Why is he in prison? Why is he there? Can't they keep him safe in jail like all the other people waiting for their trials? Right? Even like Mitch Westerman, the leaker. Anyway, different crimes that they're accused of, I know, but sure. Anyway, they go like this. This coercive environment was initially the product of Ellen being detained in an observation cell used for convicted inmates with suicidal ideations. The single cell, located in A pod, is one of approximately 60 individual segregation cells, all containing felons convicted of crimes such as burglary, robbery, C, M, and murder. Each and every one of these inmates had the ability to communicate with Ellen by yelling at him at all hours of day and night, and by chastising him every time he was removed from his cell for the purposes of recreation, showering, other admin reasons. Of course, that sounds like prison life. It's terrible, I'm sure. But what's he doing there? The jury hasn't decided if he's innocent or guilty. And the state prosecutor's shaking in his damn boots. From what we can hear, he's worried about deepfakes. Okay. Alan's attorneys have learned that he was referred to as a baby killer, as is anyone with those charges. I understand that, but okay. A baby killer. And that he was the target of other similar accusations during his stay in the WCU. Prison records reflect that Alan was placed on YouTube. Please like and share so others can learn this information if you want them to, because I'm going to say all the words that YouTube doesn't like. And then they're like, oh, if I say that word, the S word now, then they send me an email to say, are you okay? I'm okay, guys. I'm just reading a document. Guilty of Crime says, I love you though, Gisela. Same to you. We could all have different opinions. It's okay. Just remember. Yes, Pernille reminds everyone, don't be combative in chat. Everybody calm down, take a chill pill. Very contentious topic, you know. Just like that trial, that Nicola Mew trial. Ooh, contentious one, right? That's one like, okay, so same here. We just gotta all chill and keep an open mind, okay? Prison records reflect that, it just looked like they were alien, but Alan was placed on suicide watch during the majority of his stay at the WCU, including upon his initial detention of November 2022. This occurred despite the fact that there were no underlying findings to suggest that he was suicidal. They've done that as well with like Donna Adelson, based on some statements that she made. Remember? They've done it with Troy Driver in Naomi Irion's case. He did eventually take his own life. I don't think it's a bad idea to have someone on that watch, especially if they have made those types of statements, which in the old documents they said that he had. So if he did, that's why they put him there. I totally understand that. They said, and at least he's safe from everyone else. But they say his designation as that subjected him to even harsher circumstances than those of other offenders on the unit, like Donna Adelson recently asking for a bra because she doesn't have one. Okay, which they're allowed to ask. I'm just saying that, well, I could argue, you know, with people on the other side of the page here. Yes, that's normal. Sure. Alan's designation, okay, we read that. For example, Alan's bed consisted of a metal plate with a thin mattress, all of which was just a few inches from the concrete floor. Alan was issued an anti-suicide smock, which covered his body no better than that of the garment of a caveman. Alan's food was served to him through a cuff portal, and his dining habits involved him sitting on his bed or on the floor, as his cell was not equipped with a table or chair that would otherwise serve as a rudimentary dining arrangement. This I could see standard defense stuff. I understand that. You know, where they're like, why is he being treated that? They're fine. But the bigger picture is why is he being treated like that? Why is he there? Anyway, the toilet bowl was located approximately 24 inches from his bed. Alan's attorneys learned that Alan was not only under constant surveillance, but that the lights remained on in his cell for many days and nights. That could be a little concerning unless they really think he could take his own life and they're really watching him. I don't know. But that could drive someone to a very bad mental state. It's also true that due to his S-Watch designation, he was afforded less or no recreation time and less of an opportunity for showers. See attached audio of CO Timothy Weist at 3 to 4 minute mark. In essence, his S designation was the cause for the removal of additional privileges to the extent the word privilege even applies, which in turn further fostered an environment that led to the deterioration of Alan's mental and physical health. In all, for nearly 13 months at the WCU, he was deprived of any social interaction, very little to no privacy, limited recreation time, and was left to entertain himself. Okay. Unfortunately, Alan's unusual detention circumstances would extend beyond the door of his isolation cell. Whenever Alan was removed from the confines of his 12 by 8 steel and concrete box, aka cell, he was shackled with ankle cuffs, a belly chain, box cuffs on his hands, and guided around by guards with a lead, or what most people would refer to as a leash. Now, why that? Thank you, guilty of crime. Same to you. Why, as we've seen in the courtroom, why are they treating him like Hannibal Lecter? You know, they might as well strap him on that, like, that wheelie thing. Also, you know, at this point, put like a grill on him, you know? Why is he being transported to the courtroom like that? Which someone said in the comments of the last stream we did that would taint the jury pool itself. Just seeing him like so dangerous, like here he comes, he's chained up, just like all the time, and they're going to tase him, you know. And he was apparently saying after one of those court hearings, please don't tase me, please don't tase me. I don't know. Could that be part of his defense strategy? Maybe. I keep an open mind, okay? Or, scarily, could it be the other side? I just consider the other side. What if he is not the right guy? What if he is being tortured like that? I mean, imagine then if it was one of your relatives, husband, brother, uncle, son, whatever. That's pretty scary. That's pretty scary. So they say that, I mean, we don't, again, I'm going to say it one more time because you know I snark about criminals, okay? I'm the snarkiest. But here I'm like, what is going on? Like, okay, if this is the new norm, then, well, Koberger, off you go, sir. But that's not how it works, because they're innocent till proven guilty. The jury has to find them guilty. Anyway, so as if this restriction of his basic freedom of movement was not enough, prison officials assigned to a videographer to Alan to record his movements around the prison. That's kind of weird. They're almost like vlogging his daily life, including when he would meet with his lawyers. Did they do that with everyone or just him? Right? Yeah, Debbie says, treat him like Brian Koberger. Special. Very, very special. It's ridiculous seeing all that, right? Don't point the cameras at him. He can wear his little suits and he can be there. And what? Look at what he's accused of. But sure. And Chad Daybell as well. In his little baby blue outfits. Ugh. Okay. During all the meetings between Alan and his attorneys, he remained shackled, as referenced above, making simple tasks difficult, such as taking a drink of water from a bottle. Alan would not be able to communicate as much as a hand gesture due to his shackled state. During other meetings, prison officials placed a video camera outside of a window in the visitation room and required Alan to sit on a hard plastic chair directly in line with the video camera, which was less than 10 feet away. Alan's highly unusual detention circumstance extended even to visits with his wife. During one visit, Alan was transported outside of the WCU to a building reserved for visitation for those inmates in general population. Alan again was shackled, confined during the transport, and ultimately re-robed into a green jumpsuit before seeing his wife. He was, however, unshackled during the visit. His embrace with his wife was controlled by prison protocol, which permitted only a few brief seconds of contact, despite the fact that Alan had not seen his wife for the better part of 6 months. Alan was required to sit on the opposite side of the table from his wife and 2 prison guards stationed within earshot of each end of his table. They were left with absolutely no privacy. The room was completely empty except for his lawyer and a few other prison guards who were also stationed within the building. This provided no background noise whatsoever, which might offer up some aspect of privacy as he and his wife tried to communicate. And his restrictions did not end here. Alan and his wife were also denied the simple concession of getting a drink of water during this visit, despite the fact that there were a number of vending machines and a water fountain within 10 to 20 feet from his table. For people that are going to say, obviously this is normal and everything, maybe. I don't think so. I don't know if this is normal, how you treat someone before his trial even starts. Think of Rex Heuermann, an alleged serial killer with a lot more evidence based on the PCA. Right, based on the PCA, a lot more circumstantial evidence. His main concern is if the other serial killer he's writing letters to gets butter on his bread. Richard Allen's concerns seem a little more serious to me, right? Now, Allen's unusual detention involves an even stranger set of circumstances. During the course of the representation of Allen, his attorney discovered the existence of dozens and dozens of police reports, audio interviews, and other investigative findings that centered on a group of suspects associated, and that was weird. At first I thought, yeah, right. And then it turned out to be true? The guards themselves provided affidavits? Okay. With pagan Norse spiritual religious practices, these suspects considered themselves Odinists, all of which were referenced in the Franks motion and memorandum and second Franks motion and memorandum previously filed with this court. Allen incorporates herein the details referenced in the Franks filings rather than restating the lengthy details in the memorandum. Allen's lawyers also discovered that at least 2 guards assigned to his pod and or his movements around the facility also held themselves out to be affiliated with the pagan Norse god known as Odin. See the affidavits of Joshua Robinson and Randy Jones. The guards proudly displayed their Odinistic beliefs on their own prison uniforms, despite the fact that such a display was in direct violation of the uniform policy. And, on at least one occasion, one of these guards tased Allen after he was placed into his secured 8x12 cell because Allen refused to remove his hands from the cuff port in the door of his cell. A cuff port that is barely large enough through which to slide a meal tray. Allen posed absolutely no risk to anyone at the time that he was tased. Okay, Allen had also battled depression throughout most of his adult life. He was medicated over the course of his life and in fact had sought out therapeutic resources to treat and manage his depression. The IDOC gave very little consideration to Allen's condition at the time of his intake and initial incarceration in the WCU, especially given the unusual circumstances in which he was detained. It's also believed that Allen's medications were administered in a less than consistent fashion while he was on the unit, all of which would have contributed to his inability to endure his living environment during his pre-trial detention at the WCU. Okay. Oh man, Precy says, look at Israel Keys and how they coddled him. Look at Ted Bundy. He was literally able to bang his wife right there in his visits. Produce a child. Oh my word. Not saying that's the norm or should be. No. It's just like, wow, I've never seen anyone treated like this. You know? Okay, so issue. The issue in this case is whether the state violated Allen's 5th and 6th Amendment rights and federal and state due process rights by detaining him in solitary confinement in a maximum security prison segregation unit while he was awaiting trial. Allen's statements were involuntary and should be suppressed. Okay, so rule. Coercive police activity is a necessary predicate to finding that a confession is involuntary within the meaning of the Due Process Clause. Colorado versus Connolly. However, coercive police activity is not a necessary prerequisite to challenge the voluntariness of a defendant's statement under Article 1, Section 14 of the Indiana Constitution, as there may be other elements that would tend to support a finding of involuntariness. State versus Banks, they give obviously citations, citing other cases. I'm just going to read the document to you here, not to go off on a tangent now to look at those. The proper standard under the Indiana Constitution is where the confession was freely self-determined and the product of a rational intellect and free will. Thus, courts look to the totality of the circumstances to determine if the confession was voluntary, taking into account many factors, including 1. Whether the statement was made under a court order, 2. The use of police trickery, 3. Threats or promises by police, 4. The defendant's race, age, or disability, 5. Length of detention, 6. Physical coercion, or 7. Illegal police practices. Okay? Local Clown Crew says it's not constitutional to hold anyone on these conditions, and yet Indiana prisons do this. Andrea Saunders says Shawshank Redemption comes to mind. Now that is a good movie. That is a very good movie. But yes. Analysis. Notwithstanding, we're now on page 6, as you can see here. Notwithstanding the lowest standard, we're getting to the confessions, okay? If you're just here for that, it'll be timestamped, okay? Replay watchers, make sure you look at the timestamps in the pinned comments, okay? Or the description box, or hover over the video. Instead of saying, just get to the point, Gisela. It's always funny when people say that. Okay, notwithstanding the lowest standard for showing involuntariness set by the Indiana Constitution, it is indisputable that Allen's detention circumstances were manufactured by the Carroll County Sheriff purposefully and without the existence of any sense of due process, as the court signed the safekeeping order without requiring the state to establish the burden of proof required by the statute. But this was just the beginning. Allen was then shipped off to WCU and immediately placed on suicide watch in a detention cell where he had little to no accommodations, not even those offered up to the other 2,000 convicted inmates housed across the prison yard. Sure, almost simultaneous with Allen's isolation from human contact, prison companions, oh dear, prison companions were placed at his doorstep and tasked with the duty of reporting his every move and recording his every word. I don't know if that's normal. Is that normal? Anyway, the companions appear to have gone above and beyond this duty by communicating with Allen about his case, and even praying with him as he struggled to withstand the rigors of his incarceration. Their mere presence at his doorstep is akin to Messiah versus United States, where the police obtained incriminating statements from a jailhouse informant who engaged the defendant in a conversation and developed a relationship of trust and confidence with the defendant such that he revealed incriminating information about the charged crime when counsel was not present. Then they say they've got a case reference there. The court held this was improper and suppressed the statements. This trial court should do the same. All right. The trial court's decision regarding the admissibility of a confession or incriminating statement is controlled by determining from the totality of the circumstances whether the statement was given voluntarily rather than induced through violence, threats, coercion, or other improper influence so as to overcome the defendant's free will. In this case, I think that could be a possibility. It's not normal that these Odinist gods have their patches and their face tattoos, tasing him and all that. If that's really happening, that is not normal, right? Anyway, so they said standard indicators for voluntariness include whether the confession was freely self-determined, the product of a rational intellect and free will, without compulsion or inducement of any sort, and whether the accused's will was overborne. Here, Alan's free will was overcome by the forces of his environment, all of which were placed upon him by the government and its actors. Alan, a man with a bona fide pre-existing mental health issues, was detained in an isolation cell, entirely isolated from any sense of meaningful human contact, and then offered up the most basic amenities of life through a cuff porthole in his door. Don't let Chad Daybell hear that he had a porthole. He was reduced to sleeping on a mattress that was placed on top of a steel plate just a few inches from the floor. The same mattress and floor also doubled as his dining table because his cell had no such accommodation. His attire was reduced to nothing more than a suicide smock covering only a portion of his body. Alan's healthiest accommodations came in the form of recreation time, not to exceed 4 hours per week. In this space, there was not enough room to jog or run, only an exercise bike and a pull-up bar. Alan's other accommodation would have been a window slit that was inside his cell. His view of anything outside of the boundaries of the penitentiary would have been impaired by the rusty chain link and the razor wire of at least 2 separate fences between him and any sense of freedom. To the extent that Alan was ever allowed to be removed from his cell, he was shackled at the ankles, wrists, further confined by a belly chain and cuff port, and guided around by the prison on a leash. All ideal ways to confine and control the movements of a convicted killer or some other convict who, in addition to his conviction, posed a threat to himself or the prison staff. Alan, at 5 feet 5 inches tall and 173 pounds soaking wet, and with not one single criminal conviction on his rap sheet, met none of these conditions. See WC Suicide 4, 11/8/22. As if this treatment wasn't enough, Alan was forced to endure the intimacies of his restraint systems even while he was meeting with his court-appointed lawyers inside the confines of the maximum security segregation unit located inside of the Westville Correctional Facility. And to add insult to injury, Alan's meetings with his attorneys occurred while he had a video camera aimed at his face, recording sessions that should have been afforded the most private of environments so as to protect the relationship between the attorney and the client. All of this occurred while Alan's medications were being adjusted by the prison medical team, the combination of which factors reduced him to nothing more than a human experiment. Alan's free will was overcome. Yeah, I don't think they should be messing with the medication. That can already cause big problems, right? Under the Indiana Constitution, the voluntariness of a confession must be proved beyond a reasonable doubt. I think there's a lot of reasonable doubt in this case, whether one likes it or not. I know a lot of people don't like that. A lot of other people know there's a lot of reasonable doubt in this case, and that's what's scary, right? One would think, wow, after 7 years, damn, like, it was like, this is your guy? So much reasonable doubt. My goodness. It's hard to believe. Especially from all the other trials we've watched, all the other cases we've watched. My goodness. Okay, this one's very concerning. Very rocky road, right? Okay. Rob says, excellent document read. Oh, thank you. Okay, so under the Indiana Constitution, right, we've got that the voluntariness of a confession must be proved beyond a reasonable doubt. And in reviewing voluntariness, such a weird word, that voluntariness. Okay, the courts look at the totality of the circumstances, reviewing all the evidence in the record rather than focusing only on the evidence supporting the finding of voluntariness. Okay, so as explained below, the state cannot meet its burden of showing voluntariness here, even applying the lowest standard of preponderance. The federal courts have a long history of regulating the admission of confessions that have been a product of state action that exploits the weak and compromised through interrogatory and custodial process. Terry says, "Hi G, love your concern." Oh, thank you so much. Yes. I'm definitely a eyebrow-raising, concerned person. Especially in this case, I'm very concerned. In Blackburn versus State of Alabama, the United States Supreme Court noted it had recognized that coercion can be mental as well as physical. Of course, we know this, right? And that the blood of the accused is not the only hallmark of an unconstitutional inquisition. A number of cases have demonstrated, if demonstration were needed, that the efficiency of the rack and the thumb screw can be matched, given the proper subject, by more sophisticated modes of persuasion. A prolonged interrogation of an accused who's ignorant of his rights and who's been cut off from the moral support of friends and relatives is not infrequently an effective technique of terror. Thus, the range of inquiry in this type of case must be broad, and this court has insisted that the judgment in each instance be based upon consideration of totality of the circumstances. Allen's case falls within these federal parameters. In Blackburn, the defendant had a documented history of mental illness, having served in the military, which ultimately resulted in his discharge because of a medical finding that he suffered from some form of psychosis. He was in the process of being treated in the days and weeks leading up to the commission of the crime and his ultimate apprehension. After enduring an 8 to 10 hour interrogation, Blackburn was given a prepared written statement with admissions offered up by him in the course of the interrogation, and he ultimately signed the written statement 2 days later. We have seen that before, those types of things, right? Here, Allen endured a longer, more sustained form of interrogation, one that lasted more than 5 months before he was finally broken. Okay, now trigger warning, buckle up, it's about to escalate from here. Already suffering from a bona fide mental health disorder, and then having been cut off from the moral support of his wife, mother, and daughter, Allen was weakened to the point where he slipped into a state of psychosis, plagued with grossly disorganized, delusional, paranoid, and highly dysfunctional behavior. These behaviors were manifested through verbal confessions that he may have been drugged, verbal confessions to the double homicide, inconsistent with the facts about the crime scene. Now, again, that is a red flag for me. I understand that the defense team here would want to make sure they get that search warrant out. Chuck, they've tried that. I know that. And, he confessed. Yeah, make sure that they discount that, right? Make sure that that can be suppressed. I understand a defense strategy. However, if what we're learning here is true, that what Richard Allen is saying in these in psychosis, allegedly, and if he's confessing but it's inconsistent with the facts about the crime scene, that's a little odd. So they said periods of not sleeping for days, paranoia, stripping off his clothes, drinking toilet water, covering himself with and eating his own feces, and many other socially unacceptable behaviors. Now, I don't think that it's okay for someone waiting to go to trial to be pushed to this mental limit. I don't think it's ever okay, actually. But especially not someone who's innocent until proven guilty. And where the case against him seems a little strange, a little bit weak, Either way, why are people okay with this? Some people argue that, no sympathy for him, who cares, whatever. This is a huge problem. So, and it's not just eating paper and breaking tablets. Now we're hearing about stripping off his clothes, drinking toilet water, covering himself with and eating his own feces. Someone said on X, where, I post quite a lot on X. If you don't follow me there, my handle is @TrueCrimeGisela. Make sure you don't follow impersonators. I don't have an Instagram. There's impersonators there too. I've seen. So annoying. Little people pretending to be me. No. Okay. So @TrueCrimeGisela, I was posting there, and someone was saying maybe he covered himself with and ate his own feces to protect himself from, the more predatory types of convicts he's surrounded by. Maybe. I don't know why someone would do that. But yeah, Yuli Jade says human rights violation. I would love to hear what you all think about this, because this is very concerning. Rob says the abuse has been unnecessary. And yeah, you guys are saying not okay. It's not okay. And you know what I don't understand is how much hatred is channeled at Richard Allen. Like, people absolutely want to roast him, grill him, basically just about kill him and laugh at this. But then in covering other cases, oh, that's fine. Like Brian Koberger, you know what I mean? There should be a standard, at least. You want the person to go to the trial, wait in jail, go to your trial, have the jury decide, and then you deal with the consequences if they find you guilty and if that's what you did. There's still cases of wrongful convictions, you know what I mean? We see that all the time. That's why the Innocence Project exists. But this, I just don't understand the energy that people have towards this of being like, yeah, good. He's innocent or proven guilty. And the case is rather shaky. So this is terrible. They said in many other socially unacceptable behaviors. On one occasion, Allen confessed to molesting those 2 young girls and shooting them in the back. Okay, in a state of psychosis, one could say a lot of things that are not factually accurate. But to me, that brings up yet again the possibility that he's being abused into and coerced into these confessions. Because if they say, we know you did it, didn't you? You did it. You definitely did it. We found an unspent round there. Apparently, days or weeks later, we found an unspent round there, and we know it belongs to you. It's your gun. So if he hears that all day, every day, if that's what's happening, and he says, okay, fine, I admit it, I molested the 2 girls and shot them in the back. The victims were not shot in the back. So that's strange to me. I like to make many, like diagrams in my mind of what the possibilities could be. To me, if one had to go all the way to the other side of what I'm saying, well, if he were like a serial killer or something, because in the beginning when he was arrested, we're like, what other crimes could he have committed? We looked at all the possibilities of where he worked as a Walmart manager. When he was arrested, he was working at CVS, right? Before that, he worked at Walmart. He was transferred around as a manager. So we started looking at other crimes. Could this be linked to the Evansdale murders? Could it be linked to Bill and Peggy Stevenson? Like, what is going on here? So imagine if he's saying that based on some other crimes. But these victims, if he's only talking about this case and this is his confession in this state, there was no sexual assault according to what all the information we know so far. No sexual assault. And they were not shot in the back. So, that's an interesting confession, right? Cake says they want to put him in prison so bad that they'll end up doing the opposite. Human rights violation equals freedom. Destroying all justice for LG and AW. Well said. Some people even say that, people who are concerned about this, like me, are like insulting the victims or don't want justice for the victims, but it's exactly the opposite. If you want justice for the victims, you want them to have the right guy. You want him to have a fair trial. And if Doug Carter said tentacles, many tentacles, and there could be so many other arrests and whatever, the state prosecutor said he doesn't want to release the PCA to the public because there could be other arrests. Where are these other arrests then? Who are these other people? Well, we've got Anne Hunch, don't we? Robin said, my mom's dementia, she said, insane, untrue, not okay. Thank you, Robin. Okay, so, yes, one more, and then I'll keep reading. We've got to take little breaks every now and then because it's very intense, right? It's very dark, very intense, very concerning. Brian and Jill W. said, shame on Indiana for putting RA in the situation before he's even tried. Did he waive all his rights as a U.S. citizen? I think not. Okay, and when people say, well, obviously, he confessed, so he did it. Which other killers have you seen confess? Have you ever seen alleged killers, suspects just suddenly confess? Do you see Rex Heuermann confessing? I don't think so. Brian Koberger? Nope. Do you see Adam Montgomery confessing? He didn't even have to be at his own trial. This one's already been ordered. He's going to be there with shackles and tased people all around him. People with tasers all around him. It's so different, It can't be that different in one country, right? Like, what the heck is going on here? On one occasion, Alan confessed. Okay, we read that. On another occasion, he professed his sorrow for molesting Abby, Libby, and others, which he specifically named. They say CO Michael Roberts' statement between 15 to 16 minute mark, which we could see those won't after trial, maybe after the trial, I don't know. These facts are known to be falsities, none of which are supported by the autopsy findings by Dr. Roland Kaur as to the cause of death of the girls, and unsupported by the absence of any evidence that either one of the girls was sexually assaulted near or before the time of their deaths. See attached autopsy reports regarding Abigail Williams and Liberty German. At the time that Alan uttered these falsities, the state's actors were in the ready position with pen in hand documenting the entirety of Alan's mental and physical deterioration and actions stemming therefrom. The infringements on Alan's legal rights didn't stop here. Inmate companions then spread the good word of Alan's confessions to inmates in general population at Westville, prompting these inmates to then share the information with their respective family members in public. Proof of these leaks were offered up by the state in the form of audio-recorded interviews and accompanying transcripts, and included in large volumes of discovery dumps received by the defense in the recent past. However, neither Alan nor his legal teams are aware of any self-reporting of said leaks by the state to the defense. Ooh, calling the state out for some leaks, are we? I like that because the state's always like, you leaked this and this. Well, did you also, McClelland? Okay, or by the state of the court, despite the fact that the state was aware of this information as early as May 12th of 2023, when Patton and Elliott were interviewed by law enforcement investigators. Alan's due process rights have been all but ignored, including by the judge, in my opinion, based on everything we saw, right? It is also established that the 14th Amendment forbids fundamental unfairness in the use of evidence, whether true or false. Lezenba versus People of the State of California, there's another case that they cited there. As important as it is that the persons who have committed crimes be convicted, there are considerations that transcend the question of guilt or innocence. Thus, in cases involving involuntary confessions, this court enforces the strongly felt attitude of our society that important human values are sacrificed where an agency of the government, in the course of securing a conviction, wrings a confession out of an accused against his will. This insistence upon putting the government to the task of proving guilt by means other than inquisition was endangered by historical abuses which are quite familiar. Remember that guy that Andrew Baldwin emailed by mistake, that little summary of what's in the discovery? Brandon Woodhouse, he's got a YouTube channel, and he's got a lot to say about how the prosecutor operates, right? It's pretty interesting. So if you go find it out there, it's out there somewhere. I think it's still out there. Okay, so they say the truth or falsity of Alan's statements are of no consequence to this analysis. Alan has been treated unlike I agree with this. He's been treated unlike any other pretrial detainee in Indiana, or probably the country or the world, in recent history. The methodology employed by the justice system is one of first impression, and therefore the circumstances created by this methodology should not be part of any consideration of Alan's guilt or innocence. The system of pretrial detention employed against Alan runs afoul of the 5th and 6th Amendments of the United States Constitution and Article 1, Section 14 of the Indiana Constitution. It is for these reasons any and all incriminating statements made by Alan while incarcerated should be suppressed. Do you agree with that or no? Do you think it should be or shouldn't? I think even if it isn't suppressed, okay, McClelland, tell the jury, because I think the defense will have a lot to say as well. And they will then see, well, that doesn't match the autopsy or the crime scene at all. You know what I mean? So, also, I'm sure you guys know of Andrea Burkhart, who's an attorney with a YouTube channel. She said, you might think that being psychotic when you confess would be a good reason to throw it out, but not according to SCOTUS. There must be state coercion or it's admissible. Rosie is making a great record here for appeal. And then, wait, there's other comments here quickly. I then asked Andrea if an alleged psychotic confession does not match the crime scene, then what? And she said it'll be up to the jury to decide if it's credible or not. Yes, let the jury decide. Okay, state, let the jury decide. So they said, so if it'll be up to the jury to decide if it's credible or not. All right, so that was there. I just want to quickly see if there's anything else. Yes, that's it. That's it for now. If you want to see the other comments, it is on X because I made a post and then Andrea had requoted it and lots of people had answered me about it. So if you want to be part of that conversation there, please join us on X, okay? I could always use all the Grizzly support over there as well to like join in the conversation, you know? Okay, so now that's what we read there. So here they've got this motion to suppress statements, right? And they say the defendant, Richard M. Allen by counsel, Bradley A. Rosie, respectfully requests that this court suppress as evidence in this cause any and all oral and written communications, confessions, statements, admissions alleged to have been made by defendant Allen during his pre-trial detention in this cause. It's also weird to me, okay? I was just thinking, so this happened within like a 3-month period and then everything got better? If one had to go all conspiracy theory, as people already accuse one, you could say, well, they got what they wanted. They, being the government, the state, they got that confession that they so needed because the rest of the case is pretty weak. They got a confession, right? And then he got better? They took the pressure off a little bit or what? They moved him somewhere else? I don't know. I don't know what to say about this. There's just many possibilities. And if you really go down the rabbit holes of some possibilities, it's very scary and definitely an anomaly in how things normally work. We don't normally see this at all. So they said defendant Allen is charged with 2 counts of felony murder, counts 1 and 2, and 2 counts of murder, counts 3 and 4. During the course of the defendant Allen's pretrial detention, it's alleged that defendant Allen communicated incriminating statements to state actors and or their agents, all of which the state of Indiana intends to present to a jury at the trial in this cause. Of course, again, in the conspiracy box of things, which I think is actually quite logical and plausible in this case, but in that box of things, is that why they put him in the prison? To be in that type of environment, to be filmed with the lights on, in the smoke, you know, in that type of condition, and push, apply pressure. He makes the confessions, he's all psychotic and all that. The medications are being tampered with, is what they've said before. Okay, and then when they get their confession, okay, as we'd say in South Africa, shop. That means, okay, if you're South African, you're going to know. Shop, they've got what they need, moving on. All right, so the statements were involuntary, thus obtained in violation of the following: the 5th Amendment of the United States Constitution, the 6th Amendment of the United States Constitution, the 14th Amendment of the United States Constitution, and Article 1, Sections 12, 13, 14 of the Indiana Constitution. The statements sought to be suppressed were obtained as a result of psychological and mental coercion, illegally directed against the defendant, and such statements were therefore involuntarily given. Would any defense attorney representing a client like this do this? Yes. It's a normal strategy. But is it a normal situation? If you look at the totality, as Dakota would say, the totality of the circumstances. One day you want to know what we know, and one day you will. Yeah, we hope so. We sure hope so. Blackwooder's like shop. So it's sharp. It's like the word sharp. Shop. Right? The statements, wait, did I read the last sentence? Yeah, okay. The statements, yes, okay, sought to be suppressed were obtained as a result of physical coercion illegally directed against the defendant, and such statements were therefore involuntarily given. Do you agree with that or not? And you don't have to. You don't have to. If you don't agree with it, let me know. If you agree with it, let me know. What do you think? Okay? And don't fight with each other, no matter what your answer is. Okay, so therefore, any and all communications, confessions, statements, admissions alleged to have been offered up by the defendant Allen were elicited in violation of his constitutional rights under the 5th, 6th, 14th Amendments to the Constitution of the United States, and his rights under Article 1, 12, 13, 14 of the Indiana Constitution. Wherefore, defendant Allen by counsel respectfully requests this court conduct a pre-trial hearing. We know what Judge Gold's going to say. Denied. She just like denied. Everything denied, except McClelland. Ooh, what do you want? Yeah, granted. Right, so conduct a pre-trial hearing to determine if the statements alleged to have been given were voluntary in nature, and 2, suppresses evidence in this cause any and all communications, confessions, statements, admissions, written or oral, made by him subsequent to his arrest in this case, right? Oh yeah. This is another document. I told you there's so many of them. Just hold on one second. Okay. So, all eyes on Delphi. said it's not about singling out RA as if he's the only one being abused, but in order to achieve overdue reforms, it has to be achieved by one to set a new precedent. Absolutely, right? Wow. Vicky Horton said, I work on a psychosis ward. This sounds like our most seriously ill patients. And then you get people like Lori Bello that play games, literally playing games, okay? And then she's found incompetent to stand trial multiple times. Of course, she went to trial. She was convicted, sentenced, all of that. But do you remember all those delays? Remember all that? Remember Letitia stuff? You know what I'm saying? But here it's like, oh no, this is fine. This is just normal. Grill the guy. Like, why? So, let me just see what this one is. Is this the same one? Wait. Oh, that's the appendix of exhibits that they have here. Which they better not leak any of this. Nobody leak any of this. Okay. Appendix, list of exhibits. Court order, safekeeping order, November 3rd, 2022. Deposition of Warden John Galapau. Hope I'm saying that right. Certification of certain questions in the deposition upon oral examination of this guy, who is the prison warden, right? I think, if I remember correctly. Yeah. Jennifer Duncan says, denied. I know, I hear it already. Denied. Affidavit of warden. Okay. John Galapau, Westville Correctional Facility. Report of Treatment Review Committee, TRC hearing. Audio statement of Michael Roberts. In DOC, Adult Mental Health Order 11-322. Westville video. Audio statement of Timothy Weist. Affidavit of Sergeant Joshua Robinson, Westville Correctional Officer. Affidavit of Sergeant Randy Jones. We've seen those two things before. Westville Correctional Officer. They said, yes, we wear the patches. Westville video. Independent Neuropsychological Evaluation. Dr. Polly Westcott. WCU Suicide Monitoring 11-822. Autopsy report of the two victims. Statement of inmate Lacey Patton Jr. and statement of inmate Jason Elliott. Okay, so we've got that. And finally, this is a 2-page document. Very quickly, they said they respectfully request that the court issue the defense, of course, an order granting leave of court, allowing the defendant Allen's legal team to conduct depositions of inmates at the Westville Correctional Facility. In support of said motion, defendant Allen states as follows. The parties are in the process of conducting discovery by way of depositions in preparation for the May 13th, 31 days away, 2024 jury trial in this cause. 2. The state in its witness and exhibit list dated March 8th, we just read it, has identified a number of maybe that was a different one. A number of correctional officers and inmates that the state intends to call. No, I think that's what we read. Wait, let's see when it's dated. That says 11th of April, but okay. Has identified a number of correctional officers and inmates that the state intends to call as witnesses in this cause. Ooh, that's going to be interesting. Most, if not all, of these inmates are associated with the Westville Correctional Facility, where defendant Allen was housed over a year before his transfer in December of 2023. Another concern is other inmates that have written to the judge, to Judge Gold. Lots of concerned citizens and inmates writing to Judge Gold. Do you remember that guy? What is his name? His name escapes me now. But he wrote multiple letters to Judge Gold saying that Richard Allen's being abused and he's being tased and all the things, right? I mean, he's putting his own life on the line by doing that. Okay. So they say the defense desires to depose one incarcerated individual, Jesse James, DOC. Apparently he's been accused of sexual misconduct with minors, something like that. I'll have to look into that. So that's going to be interesting. They're probably going to grill that guy, get answers out of him. Attorney Rosie believes that inmate James is currently housed in the Westville Correctional Facility. The Westville Correctional Facility is located in a fairly remote area. Attorney Rosie has attempted to secure a location to conduct said depositions in the town of Westville, just a mile or two down the road, but has been unable to do so due to the fact that Westville is a very small town with very few locations that are suitable for such a circumstance. Attorney Rosie was able to seek out and secure a space at the LaPorte County Sheriff's Department in LaPorte, Indiana, approximately 20 miles from Westville Correctional Facility. This is the closest and most accommodating location where Attorney Rosie was able to secure an adequate space to conduct depositions of the above referenced inmate and other prison employees not referenced in this pleading. Attorney Rosie respectfully requests this court issue an order granting his request to conduct depositions of inmate James. Attorney Rosie has made arrangements for said depositions to occur at the LaPorte County Sheriff's Department on Thursday, April 18th. Ooh, that's just around the corner. commencing at 8 a.m., at which time Attorney Rosie desires to depose inmate James. And Attorney Rosie requests that this court issue an order granting leave of court and directing the Indiana Department of Corrections to transport inmate Jesse James to said deposition and thereafter return Jesse James to his respective location of incarceration. My goodness, that was a lot of documents, right? And if we don't keep up with it, oh my, and then it just keeps piling on. So we gotta discuss it as we go, especially when it's important things like this, like alleged confessions that are not matching the crime scene. It's a little weird, right? Steel Guitar says, gee, forgotten names bother you as they do. Steel Guitar, remember now. Robert P. Baston, wasn't that his name? He wrote many letters, right? Now Jesse James is at the Westville Correctional Facility, and his charges are for sexual misconduct with a minor. So they're going to depose that guy. Hope said, it makes me sad that Abby and Libby might not get justice with all these shenanigans going on. Great job, Gisela. Oh, thank you so much. It makes me sad too. Absolutely. Right, so that's what we have. Another document that is very interesting that you may have seen being read, okay, on other channels. I know the Defense Diaries read it as well. The transcripts of, the hearings from March 18th. I'm very interested in this afternoon one. There were 3 hearings on the day where one of the investigators that looked into the Odinist angle, he testified that day. He was questioned that day, and everything that he said is just very interesting, right? So we can go through that at some point as well. I'm just still also just like reading it little by little. I'm just like, what? And then I need to take a break again. I'm like, this is so much, okay? So just not because of the amount of pages, just like it's a lot to process of just the possibilities of this case, right? Scott H says, thank you for all your work, Gisela. Thank you so much. I really appreciate it. Okay, so that is what we have for today. Okay, that was a lot, I think. Let me know what you think in the comments about everything that we discussed today. I'll keep you posted, of course, when there's any other updates. Let me just check if there's anything else that just came in. There is something that has been filed today. Hold on. Okay. I'm just quickly looking. Okay, let me read this quickly. Thank you, MB Inc., for sending me this. It says April 12th of 2024. What's the date? Yeah, that's today. Filed today in what? Carroll County? Honorable Francis Goll, Special Judge for Case, Carroll County Circuit Court, 101 Maine. I don't have the actual PDF, so I'm just reading it from what MB Inc. just sent me. Just hold on. To whom it may concern, pursuant to the Access to Public Records Act, IC 514-3-5, the Journal and Courier requests a copy of questionnaires mailed to prospective jurors in the case number, right? State versus Richard M. Allen. Oh boy. Yes, you go, Journal and Courier. Okay, they want a copy of question. That's going to be denied, isn't it? Denied. Okay, request a copy of questionnaires mailed to prospective jurors in this case. I can be reached at, there's a phone number and email, which of course, that's fine. It's public information, but Judge Gold just puts everyone's name, surname, email, just everything out there, Anyway, they said, according to the statute, you have 24 hours to respond to this request. Go, Journal and Courier. If you choose to deny the request, you're required to respond in writing and state that the statutory exception authorizing the withholding of all or part of the public record and the name and title or position of the person responsible for the denial. Thank you for your assistance in this matter. Respectfully, Ron Wilkins, reporter. Okay, our hero today. Damn. Okay, so they want access to public records. They request a copy of questionnaires mailed to prospective jurors. I like that. Because you just never know. People have already said in the comments, well, you know how it goes in Indiana, in Delphi, like all the corrupt police and the prosecutor will be threatening potential jurors, or if they know who they are, they'll tell them like, you better otherwise or else, or whatever it is. And I'm like, that sounds really scary. If any of that's true that locals are saying sometimes, I'm like, that sounds like a very scary place to live. I think if I lived there now, I'd have so much anxiety, I would just have to move. Oh my goodness. But that's not the solution. You know what I mean? So, yes, I get a lot of heat sometimes for being a foreigner, a South African, the way people say it. This South African, sitting there in Switzerland talking about this. Well, yeah, Americans could sit there and be concerned about what's happening in the Ukraine. Am I right? We're concerned. Like anyone can be concerned. This is very concerning. And as you know, my go-to is usually to be I try hard, right? The whole innocent to proven guilty it's valid. But when it's someone like Adam Montgomery, right? And it's his trial, and I'm like, whoo, just hold me back because I'm going to snark it up now. Especially because we know his background, right? It's normally pretty difficult to be like, this guy, look what he's accused of doing. Well, in this case, it's just a little bit different. It's very scary, right? And he is innocent to proven guilty, as are all these others. Like Brian Koberger, happy, very happy to sit in jail for years. And Taylor, his attorney, is like, psh, might never get to trial. And he's just like, okay, he's fine with that. He's just sitting there like he's fine with it. Well, if he was in Richard Allen's position, would he be so fine with it? I don't think so. Law Nerd Amber says, if we accept one person being treated like this, it's a downhill slope to authoritarianism. Please remember, it's about what we the people, not about Mr. Allen. Exactly. And it could be any one of us. I say that, of us. I know I'm not American, but you know what I mean? It could be any one of us. If it happens to Richard Allen, it could happen to any one of you. I'll say it like that. And that's scary. Or your family members. No one wants that. So, lastly, I would like to say, because I don't know, what are we doing tomorrow? Who knows? Are we live? Are we not? What are we doing? Make sure you subscribe with the bell on, okay? I want to say happy birthday to Rob McMullen, who's here in the chat. Rob has been a member of this channel and a patron since I launched membership, since I started Patreon, and he's one of the top tier supporters. So thank you, Rob, for all your support. I wish you a very happy birthday for tomorrow. If you guys follow Rob on X, you can wish him there as well, okay? So, now, if you are on Patreon, we're going to have a Patreon-only stream right now. The link has been sent to you on email. It's there on Patreon if you have the app. If you see your emails, whatever it is, we're now going to have a Patreon-only live stream, which is different to a YouTube members-only live stream, okay? So, I will see you there. Thank you all for the support. Thank you for those who understand why I'm concerned. I'm not sure why people aren't. It feels risky. This feels very risky. And I like to analyze risk. What is going on here? It seems very risky. This trial is going to be quite something. Dr. Bullbutter, I always like your name. I have so much to catch up on. It's a lot, right? It's a lot. So, thank you so much, everyone. I'll see you all. If you are Patreon, I'll see you now in another live stream. We'll be chatting about Gypsy Rose, the Aurora dentist who poisoned his wife. I've got a couple of cases lined up for you. Severed legs found in places. What is going on in that case? We're going to talk about a few cases now. And for everybody else, I'm going to see you probably tomorrow or the next day. I'm here almost every single day. Okay, bye everyone.